Hello and welcome to Chapter 13 in Healthcare Supervision. We are talking about criticism and discipline, guts, tact, and justice. Now, as a manager myself in the past, this is so difficult. It's hard. Even in your personal life, think about times you like to actually receive criticism. I mean, who wants that? I mean, we all want to live in our little bubble thinking we're perfect and we do everything right every time. But I mean, we're humans. We make mistakes. So that's, not going to happen. And some people are brave enough and kind enough some of the time to call us out on that. So that's what we're going to talk about in this chapter. Now, following along with the PowerPoint, but again, we're starting on page 231 in the text. I want to cover two of these key terms before we get to them in the chapter, and that's going to be discharge and dismissal. And we'll learn the subtle difference in context later. But discharge is the involuntary termination of employment for disciplinary reasons involving violation of policy or work rules. And dismissal is involuntary termination of employment for the inability to meet the standards of the job. So you have discharge and dismissal. They're both involuntary termination. So the employee is not resigning or quitting themselves. They are being let go, but there's a difference. One is a disciplinary reason and there's a violation of something, policy or work rules. Dismissal, you're being let go because you can't meet the standards of the job. So they are two different things. Now, in the slide deck, the second slide that says for the record, we're going to bypass that one because whoever built this PowerPoint, that slide is in the wrong spot. It's later on in the presentation as well. All right, so starting over on page 233, we're going to pick up with criticism. Anyone who has been a supervisor for any length of time will have found it necessary to criticize someone because of conduct or work performance. I can attest to this. This is the case. Yes, I've had to try to constructively criticize employees on how they were doing something or point out that you're not meeting your goals because of this and so forth. Also, persons with experience in supervisory positions will have found that they are sometimes targets rather than sources of criticisms. Raising my hand again, I've been criticized up and down the block many times as a supervisor. The first-line supervisor is in the position of having to take criticism from above for everything that's wrong with worker conduct and performance, and take criticism from below for everything that's wrong with the organizations and its policies and practices. Can I get an amen? That's all I'm going to say about that. Think about the last time you were criticized. Try to remember how you felt, how fair or unfair the criticism seemed to be, and how the critic's attitude and words actually struck you. Then, keeping in mind how you believe criticism should actually have been handled, try to put yourself in the position of the critic. You are likely to find that criticism is no more pleasant to give than it is to receive. All right, so when you're the one taking criticism, when you are criticized, whether by an employee, your supervisor, or another member of management, a medical staff member, or someone outside the institution, remember these guidelines. Hold your temper. Make up your mind that no matter what is said, you're going to stay calm. Don't jump to conclusions based on possibly harsh, uncomplimentary, or unfair remarks you may be hearing. Whatever you do, stay calm. Second, listen completely. Often when you are hearing something critical of yourself, the temptation to react is so nearly overwhelming that you're thinking of how you're going to respond while they're still speaking. To strive for an open mind and the ability to listen completely, try imagining yourself in a position of a neutral third party. Act as though you're hearing about someone else and not yourself. So listen to everything they have to say. Third, consider the source. The often heard advice to consider the source reached cliche status long ago as justification for ignoring criticism you simply do not want to hear. However, this expression often retains a degree of validity. Ask yourself the following questions. What are the person's credentials? Is this person qualified to criticize in this instance? What are this person's motives? Are there any vested interest involved? And are the comments valid, or do I just happen to be a convenient target? Whenever you're criticized, especially by your supervisor or another member of management, try to determine whether the person is generally trying to help you improve. Fourth, evaluate the criticism. Try to judge whether your critic had all the facts available and whether, quite simply, the criticism made sense. Search for positive suggestions in the criticism and try to determine whether you will benefit by following your critic's advice. Fifth, keep it in perspective. Some people, and it does not pay for a supervisor to be among them, do not take criticism well. They can be absolutely crushed by a few harsh or critical words. Realize, however, that criticism, no matter how harsh or ill-directed, is not the end of the world. More often than not, it is business as usual while interpersonal relationships drift back toward their original state. Criticism, unless carried to destructive extremes, is simply words strung together. And I like this quote. As Mark Twain said, if criticism had any real power to destroy, the skunk would have been extinct long ago. And lastly, follow up. Having evaluated criticism directed at you, you can do what you wish with it depending on how deserved you believe it was. If you can honestly accept what you have heard, then take steps to change your behavior accordingly. However, if you feel you honestly cannot accept the criticism, that it's either misdirected, undeserved, or unduly harsh, you have still gotten something from it. At the very least, you have learned to be a bit more about the person you've at least learned a bit more about who did the criticizing. Now, the next section is when you are giving criticism. Supervisors are often reluctant to criticize employees. This reluctance may be rationalized as owing to our unwillingness to take the chance of hurting others' feelings. However, it is likely that the reluctance to criticize is just as readily attributable to the supervisor's natural resistance to performing what to many is an unpleasant task. Certain kinds of behavior may deserve criticism and may perhaps even be deserving of disciplinary action. The reason for criticisms are generally incidents of misconduct or poor performance, or some behavior that is a manifestation of a poor attitude. Misconduct hinges largely about the existence and application of rules. Its presence is often clearly cut. Poor performance, on the other hand, often relates to assessments of quality and other judgments that are at least partly subjective. So subjective means it's opinion. So the line separating what is deserved from what is undeserved is likely to be indistinct. Dropping down, criticism is necessary, but it is valid if only it is truly constructive. First and foremost, criticism should always include guides for correction. Simply telling people what they've done wrong without suggesting how they might do it correctly amounts to no more than placing blame. Criticism should always focus on the problem, on the results of a person's behavior, and not on the person who created the problem. So, criticism should also be timely. It must be delivered as soon as possible after the behavior occurs or the results are discovered. Saving up criticism for some special upcoming contact, let's say a performance evaluation, is ineffective and could be damaging. Criticism should also be private. Never criticize an employee in the presence of other people. The words that pass between the two of you are no one else's business. And criticism should also be rational. Never criticize in anger. Take the risk of blunting the impact of your criticism by allowing yourself time to cool down and assess the situation calmly before criticizing. Often, when your anger has dissipated, you will be able to see dimensions of the situation that were previously hidden by your emotional state. So angry you can't see straight, so when you calm down, you're a little more clear-headed and you see things differently. All right, so let's talk about discipline. Moving over to page 236 in the text. So a bit of research into the origin of words reveals that discipline comes from the same root as the word disciple, and as such actually means to teach so as to mold. Originally, teaching was the key to discipline, to shaping or molding the disciple. However, we have come to think of discipline, and thus disciplinary action, as punishment. But the true objective of discipline should not be punishment, it should be correction. Thus, any one of the primary requirements of disciplinary action is that the employee be afforded the opportunity to correct the behavior that prompted the action. All right, conduct versus performance. Separate progressive paths. In all but the few legitimate instances in which immediate termination is appropriate, corrective action must be progressive. That is, it must follow through a number of steps in which the subsequent similar infractions are addressed with increasing severity. At each step in the progressive process, two pieces of information must be made clear to the employee: what the person must do to correct the problem, and what may follow if the problem is not corrected. Throughout the process, it is essential to view the sequence of occurrences exactly as it would be viewed, and often is viewed, by an empowered outsider such as an investigator for civil rights or an employee advocacy agency, by asking, was the employee given reasonable opportunity to correct the offending behavior? In applying corrective action, it is also necessary to make a distinction between problems of conduct and problems of performance. Although traditional progressive disciplinary processes may work well for the problems of conduct, such processes are not appropriate for performance problems. The employee who has broken no work rules and violated no policies is not appropriately handled with the progressive disciplinary process for work performance that falls short of the standard or expectation. The supervisor always needs to ask, is the employee not capable of performing as expected under present circumstances? If the employee cannot, for one reason or another, perform as expected, it is not a discipline problem. And to treat it as a discipline problem is to burden the process with a layer of negativity that only serves to impede correction. So, let's talk about problems of conduct and the progressive discipline applied there. So our first step is going to be counseling. One-to-one, supervisor to employee. The employee should be told what was done wrong, why it was wrong, what the organization's rules are concerning this behavior, with either a specific use of handbooks, policy manuals, and other written references, what the possible consequences of this kind of behavior are, and the period of time within the correction is expected. All of this needs to be accomplished without reference to any kind of warning. It is simply an important job-related discussion between supervisor and employee. Any such counseling session should be thoroughly documented by the supervisor in notes retained in departmental files. So after counseling, you have to move on to an oral warning. So, and you do that if that repeated instance of the same behavior follows counseling. So it should be addressed using the more formal early stages of the progressive disciplinary process, specifically the oral warning. It should be stressed that the oral warning stage, often regarded as another counseling session, should be utilized only after the employee has failed to respond to the initial counseling. The oral warning should be documented by the supervisor, preferably on a corporate form created for that purpose. And some might ask, if it's documented, is this not actually a written warning? Well, it may seem so, but there is a difference between a written and an oral warning. An oral warning stays in departmental files. A written warning goes to personnel in HR. So your HR, it's actually going to go into their, if you work in a hospital, it's going to go into their big hospital file. If it's an oral warning, it's going to just stay within the department. None of the upper management can see that. If you're interviewing for another job, like a transfer within the facility, and your hiring manager goes to HR to look at your file, they're not going to see anything. So that's the difference. An oral warning is documented, but it's kept internally within the department. And then we're going to talk about your written warnings. So written warnings come next. So it follows in turn as necessary, with the documentation automatically included in the employee's personnel file. An employee whose improper behavior has not been corrected following counseling, an oral warning, a written warning is in position in which failure to change will lead to loss of income via suspension and perhaps loss of employment. By this stage, the supervisor and employee have been together on the subject of the employee's behavior problem at least 3 and perhaps 4, 5, or 6 times. It's time for the supervisor to bring the other organizational resources into process. So, let's talk about before suspension. The supervisor should at this point, before proceeding to the suspension step, refer the employee to one of 2 available sources of further assistance: the Employee Health Service or the Human Resources Department. If in any of their numerous contacts, the employee has given the supervisor reason to believe he or she may be experiencing health problems of any kind, a referral to employee health is in order. If the problem appears perhaps to lie in employee attitude or in possible difficulties unrelated to health, the referral should be to Human Resources or perhaps an employee relations specialist or employee ombudsman. This referral puts the employee in contact with someone who can possibly point the way toward resolution of some underlying problem. Also, a knowledgeable person other than the supervisor is brought into the process, and this new participant may be able to get through to the employee where the supervisor could not. And finally, this step gives the employee one more distinct opportunity to correct the problem behavior. Okay, suspension is necessary and discharge is necessary. If the referral step is unsuccessful, suspension without pay, in many systems ranging from 1 to 5 days, an eventual discharge may follow as necessary. However, a well-functioning referral program for employee behavior problems will significantly reduce the use of clearly punitive steps of suspension and discharge. An important point concerning suspension without pay. Note in Exhibit 13.3, there is the option for the manager to waive the time-off requirement of a suspension. The manager is permitted to use this option on occasions when the enforced time off of a suspension would leave an important job unattended or an area critically understaffed. However, the employee must be strongly advised that waiver of time off does not lessen the severity of the disciplinary action as far as the official record and future actions are concerned. Should you feel you have cause to discharge an employee, you should take your case to Human Resources for a thorough review before attempting to take action. Given the legal environment of the times, most organizations today require Human Resources or administrative review in concurrence in such cases. This review will attempt to determine whether all bases have been covered from a legal perspective and whether the record clearly demonstrates that the employee was given the opportunity to correct the inappropriate behavior. Some severe infractions must, of course, be dealt with as they occur. However, an immediate firing is rarely, if ever, the answer. The offending employee should instead be sent home and immediately placed on indefinite suspension pending investigation and resolution. Not all kinds of infractions will require the application of all the foregoing steps. A mild infraction, such as tardiness, may, if it becomes chronic, eventually require all of the steps described above. A more serious infraction, such as sleeping on duty, may call for a written warning or suspension on the first violation and discharge on the second violation. And so we just covered that. So mild infractions repeated might go through the entire progressive process, but certain more serious infractions could result in immediate discharge. All right, so from the substandard performer, going over to the bottom of 239, the supervisor's primary objective should not be to get rid of the substandard performer, as is frequently the case, but rather to show the substandard performer how to perform acceptably. So what should the supervisor do? They need to review the job with the employee, the job standard with the employee, ensuring the standard is known and understood, and ideally the employee accepts this as reasonable expectation. They should counsel the employee, develop an action plan specifying what must be done to attain standard performance and a timetable for doing so. Documenting this thoroughly, as any counseling session should be documented with a copy of the complete plan supplied to the employee. Next, conscientiously monitor the employee's progress against the improvement plan, providing assistance as necessary. Remove apparent obstacles to the employee's success when possible and make reasonable accommodations to enhance employee performance. If this process does not correct the problem within the agreed upon time frame, it should be repeated in essentially identical fashion in terms of the creation of a mutually acceptable plan of correction with necessary modifications from the earlier plan based on what was encountered in the process and an agreed upon target date. Again, to the important plus. The second time the employee is taken through the corrective counseling and instruction, the process should include referral to either human resources or employee health. The reasons for doing so are essentially the same as for making this referral for an employee exhibiting conduct problems, and the advantages of doing so are likewise the same. A new person who can possibly help is brought into the process, and the employee is given the chance to address the possible underlying problem that may be causing the apparent performance problems. Depending on how much time, if any, improvement is noted from one time to the next, the foregoing process might be applied 3 or 4 times. When finally every reasonable opportunity to improve has been extended multiple times without lasting change occurring, a last-ditch deadline should be established. When this deadline arrives, employment should end unless all conditions of the plan of improvement have been met. So when all else fails, you move to dismissal. Now, this is where we get into the differences between dismissal and discharge. When it is necessary to release an employee for reasons of substandard performance, that means they're not meeting the standards of the job, the action should be identified as a dismissal for failure to meet job standards and not as a discharge. The distinction is important. A discharge for cause is a firing, and a person so terminated has lost employment through inappropriate conduct and in most parts of the country is technically not eligible for unemployment compensation. However, an individual who is dismissed for inability to meet the standards of a job is not considered wholly responsible for the termination, so the action is regarded more as a layoff than a discharge, and the person so terminated is usually eligible for unemployment compensation. So there's your difference between dismissal and discharge. If you are discharged, you are fired, you're usually not eligible for unemployment. If you are dismissed, you could still be eligible for unemployment. All right, so guidelines for fair and effective discipline. Starting at the bottom of 240, going to be making our way over to 241 shortly. So the first one, be reasonable. At all times, strive to keep the severity of disciplinary action consistent with the infraction. You know, if I'm tardy 2 days in a row, you wouldn't fire me. That's not consistent with the infraction. So stay reasonable. Second one, avoid making examples. Every employee deserves fair, consistent treatment relative to all other employees. Resist the occasional temptation to make an example of an individual for the sake of discouraging the same kind of behavior by others. Making examples serves only to create fear and resentment, and it destroys the effectiveness of discipline. Third, follow the rules. The rules in the employee handbook will not cover every situation, but they will apply to many occasions when disciplinary action is warranted. Use the rules and use them consistently. Fourth, respect privacy. Do not meddle in the life of an employee outside of the situation or outside of the institution. What an employee does on off hours is ordinarily none of your business. The only time you can be concerned with an employee's private life is when you know that person is engaged in something that can harm job performance or negatively affect the reputation of the organization. Even then, you remain on shaky ground because you're risking violation of someone's privacy. Fifth, avoid favoritism. Under no circumstances should you allow yourself to favor any particular employees over others. Undoubtedly, there will be some employees you personally like better than others. People are different and your reactions are natural. However, you must make every effort to ensure that disciplinary actions you dispense are consistent among your employees, regardless of your personal feelings towards various people. Sixth, act only on clear evidence. Take disciplinary action only when absolutely certain you are dealing with a truly guilty party. Hearsay and secondhand evidence is totally inadequate and undeserving of more than your passing attention. Last, avoid dwelling on history. When an incident is over and the disciplinary action has been delivered, forget about it. Do not bring the incident up again. Do not continually remind the employee that you remember what happened. The extent to which you can justifiably deal with history and disciplinary action is through the necessary accumulation of written warnings. This practice, of course, must be spelled out in the work rules of the organization. All right, paperwork, documentation. At several points in the process described in the preceding paragraphs, the need to provide documentation was mentioned, even to the extent of calling for documentation on so-called oral warnings. It is often too easy to delay the documentation and perhaps forget about it entirely, mainly because documentation is usually not an immediate concern. After most employment actions take place, all involved parties go forward to other concerns and do not look back. Occasionally, however, an employment action is challenged, either internally through a grievance or appeal process, or externally through civil rights or advocacy agency or a lawsuit. And when an action is challenged, all of the documentation related to it in any way is brought to the foreground. Documents related to performance or conduct problems are used to reasonably establish whether something did or did not occur, whether an employee was not spoken to about a certain problem, whether the employee agreed or disagreed with a certain course of action, and so on. These documents are used to establish whether the employee was given the opportunity to improve or correct. Human memories fade or become selective regarding certain kinds of information, and the documentation is relied upon to either support or refute certain contentions. The importance of the documentation of employment actions cannot be stressed too strongly. In the words of one investigator for an employee advocacy agency, if it's not properly documented, signed, and dated, we assume it never happened. And so, too, on the flip side of that, you want to make sure that you're documenting accurately and correctly, because that documentation is what you're going to stand on if there is a grievance. And so, our old human resources director years and years ago at the hospital, he always used to use this example. In your performance evaluation, if there are issues that occur throughout the year, things that you've been counseled on or things you've received oral or written warnings for, that needs to be documented there as well. And I say that because his example always was, if I bring an employee to his office and say, this person needs to be fired, blah, 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 here's why, blah, 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 and he goes and he pulls their personnel file, and he pulls out their last year's performance review, and it blatantly says that so-and-so is the savior of the third shift. We could not ask for a better employee. How can we fire that employee? If the documentation in their personnel file states that they are the savior of the third shift and we couldn't ask for better. So you've got to make sure that your documentation is consistent. It happens as it occurs. So again, don't wait. Again, human memory fades, and then you remember it the way you want to remember it, maybe not how it actually happened. All right, so here's our for the record. When discharge is hidden under another name. So our question is it legally risky to allow an employee who is being discharged to resign for the record so that being fired does not show? And so in this paragraph here, it talks about the discharge process should always include re-examination of the causes leading up to that point. Discharge is a serious matter, and it is only reasonable to make sure that all bases are covered. Most supervisors readily recognize that discharge is serious for most employees and potentially devastating for some in terms of personnel record that can keep a person from securing new employment. Thus, some kind-thinking managers and human resources practitioners have on occasion allowed an individual who is being discharged for cause to resign for the record. The employee is still fired, but the personnel record says that he or she quit. The object of this step, of course, is to allow the person to leave with a clean record that is not likely to prejudice potential employers. Some advice concerning the practice of allowing someone to resign for the record: instead of rightly calling it discharge for cause, do not do it. The practice may be humanely motivated and allow the manager initiating the discharge to feel better about the process, but it creates the potential for severe legal repercussions. Responding to a reference request by stating that a discharged person has resigned is untrue, so it is not an honest reference. But of greater importance is the creation of potential legal liability for the organization. Should the individual cause problems in the new employment related to the nature of an earlier discharge, there can be repercussions, including allegations of negligent hiring for the organization that provided an untruthful reference. It is best by far to simply follow policy and call a discharge for cause by its proper label. All right, so now when we have non-punitive discipline. So read through this section. A lot of information in here. I'm going to hit a couple of the highlights here. So it is controversial and largely experimental. So no matter how fair and humane disciplinary action is accomplished, it is sometimes difficult to avoid seeing it as punitive. Although disciplinary action properly taken may have its obvious positive elements in attempting to correct behavior, the warning's employees are sure to appear to some as punishment, or at least the threat of punishment. So as a result, some organizations have experimented with the concept of non-punitive discipline, in the belief that actions that are seen as punishment simply breed resistance, foster resentment, and undermine employee willingness. The non-punitive approach is based in part on the belief that placing more responsibility on the employee makes it more difficult for the person to remain hostile toward the organization. And although there are variations in its application, non-punitive discipline might work somewhat in the following manner. So on page 243, we have 1, 2, 3, and 4. So 1 says, upon committing an infraction requiring correction, the employee is informally counseled concerning the rule broken or the policy violated. The unacceptable behavior is highlighted and the appropriate behavior is described. Upon a second violation, the employee is again counseled, but this time the session is more formal and includes the supervisor's manager or human resources representative, and documentation is generated. In the event of a third violation, the employee is advised that if he or she finds the particular rule or policy inappropriate, perhaps it's time to seek employment elsewhere. The employee is given a 1-day suspension and is given options in writing. Either choose to leave or agree in writing to the requirement for corrective behavior. If the employee agrees to the correction, he or she is returned to work and receives full pay for the day off. If the employee does not agree or does not respond by some predetermined time, termination is automatic, and the day off with full pay is often a sticking point with other employees who must take up the slack created by the absence of one who is being paid to do nothing for the day. And 4, should the employee agree and return to work, but violates the agreement at some later date, then the termination is in order. So-called non-punitive discipline, non-punitive stressed in quotes, because as some see it, the process simply forestalls the ultimately punitive nature of disciplinary action to the very end of unsuccessful correction, is generally more appropriate for professional and technical personnel than for rank and file or entry-level personnel. In brief, it will likely work only with those employees who fully appreciate the implications of the day of decision and will take it seriously. All right, so moving on to behavioral contracting, bottom of 243. Similar to some respects to non-punitive discipline, especially in its applicability to professional and technical workers more so than rank and file staff, behavioral contracting is a behavioral modification approach that uses written agreements to spell out the contingencies between certain behaviors and their consequences. It originated in the fields of psychology and social work, but it has been used in the workplace for eliminating any undesirable behavior and for improving employee relations. Behavioral contracting is a structured method for encouraging change in attitude or performance using a series of steps in which the manager and employee agree that some change is necessary for continued employment. In the workplace, it's best reserved for use in dealings with more serious kinds of infractions. As in certain other approaches to discipline, behavioral contracting ensures that an errant employee is given the opportunity to correct his or her inappropriate behavior before termination is seriously addressed. All right, limited use. Moving over to page 244, the paragraph right above coaching, stopping trouble before it starts. Behavioral contracting is thus best utilized with higher level employees such as certain technical or professional staff. Also, it is time-consuming approach. If the time-consuming approach is used with other employee, it must at least be considered for others who are similarly situated. And if it is not used in any particular situation, the reasons for choosing to do so should be documented. As with progressive discipline as well, consistency is always a primary consideration. Inconsistent application of any disciplinary approach can result in claims of disparate treatment. And coaching. It is unrealistic to believe that all problems of employee conduct and all instances of substandard performance can be corrected before they start. That is, they can in all instances be avoided. No matter how effective the individual manager may be, these kinds of difficulties can be expected to occur. What the manager can control to some extent is how often these kinds of difficulties arise. The supervisor who finds the employee problems occur constantly may be overlooking his or her essential role in coaching the employees. So moving over to 245, in that left column where it starts any manager. So any manager who supervises the people who perform the hands-on work has a coaching responsibility. Think of this responsibility as an essential extension of orientation and training. Newer employees will of course require more coaching than experienced employees, but at various times it's likely that nearly all employees will benefit from appropriate coaching. Coaching is simply the provision of ongoing advice, assistance, and encouragement to the extent necessary to enable an employee to perform comfortably and effectively on a continuing basis. As such, it is much of the basis for continuing relationship between manager and employee. The effectively coached employee is far less likely to exhibit behavior that necessitates use of corrective procedures. All right, so our last little section here. Guts, tact, and justice. Criticizing employees and parceling out disciplinary action takes courage. In most instances, it is normal for the supervisor to feel uneasy. We can go so far as to suggest that we should never want to reach the point of becoming completely comfortable with criticism and discipline. This state might suggest a callousness that runs contrary to the character of an effective supervisor. An employee who has done something deserving of criticism or disciplinary action nevertheless deserves your full consideration as an individual. You must be continually aware of feelings, your own as well as others. However, regardless of individual feelings, what you say and what you do must be said and done out of consideration for the needs of the institution, its patients, and its employees. So again, we've just hit the highlights in Chapter 13. Be sure to read the entire chapter and have fun answering your review questions.